Good evening. Thank you for joining us for Deconstructing Washington's Cultural Landscape, a conversation about what happens when law, culture, and executive power converge in the nation's most symbolically charged spaces. I'm Nancy Weiss, and I'm really pleased to welcome you here on behalf of the Washington College of Law at American University. During this program, we will examine several active situations that are already changing the cultural landscape of Washington, D.C., or have the possibility of doing so, including painting over the iconic golden columns of the Kennedy Center and potentially the granite of the Eisenhower or old Executive Office Building, constructing a monumental arch in Washington, D.C., redeveloping the White House East Wing, including demolition of this section of the White House and construction of a new ballroom over a secured space, and changing the name and leadership and closing the John F. Kennedy Center for the Performing Arts for renovation, potentially including significant alteration and even demolition. Taken together, these raise a common question. To what extent does law meaningfully constrain the federal government when it reshapes the cultural and symbolic landscape of the Capitol? To help us understand the legal issues involved in these cases, we brought together three panelists with extraordinary backgrounds and expertise: Edwin Fountain, the General Counsel of the American Battle Monuments Commission; Emily Sexton of Sexton Law, and formerly Associate General Counsel of the John F. Kennedy Center for the Performing Arts; and Marian Werkheiser, a founding partner and the Chief Executive of Cultural Heritage Partners. So across all of the scenarios, several legal frameworks recur: National Historic Preservation Laws, the Commemorative Works Act, the Administrative Procedure Act, the Constitution. We'll explore today whether these frameworks operate as substantive constraints, procedural speed bumps, or litigation tools. The matters we are discussing are in litigation, so I'm going to ask our panelists to focus not just on doctrine in the abstract, but also on how these legal doctrines are actually being deployed and tested in real cases. So with that introduction, let's get started. Each of our panelists will very briefly anchor us in an area of the relevant law. So let's start. Marian. From a cultural heritage and preservation law perspective, what legal obligations attach when the federal government alters or redevelops historically significant sites? And what are the limits of those obligations? So I think we have a slide. Our next slide is just an overview of the Washington that we're talking about. And the one after that, we'll start with Marian.
Great. Thank you, Nancy. And thank you so much for pulling this session together. I'm very glad to be here with my co-panelists and talk about these very timely issues. So let's talk about a couple of very important federal laws that we have that require the federal government to listen to ordinary people, to consult with experts before making decisions that impact historic properties and our human environments. The first one that I want to talk about is the National Historic Preservation Act. The National Historic Preservation Act is 60 years old this year. And what it does is it requires the federal government to take into account its impacts on historic properties whenever federal dollars are going to be spent, when the federal government is going to issue a permit for a project, or a project is occurring on federal land. We also have the National Environmental Policy Act, which we're going to talk about.
Can you please put the next, sorry, just to interrupt for 1 second. Can you put the next slide up? Just want to make sure. Okay.
Oh, okay.
Thank you.
Are we good?
Thank you.
Yeah, okay. So while we talk under the NHPA, we talk about a federal undertaking triggering NHPA review. Under NEPA, we talk about a major federal action. And that is an action that the agency carrying out the action determines itself is subject to substantial federal control and responsibility. And that if that action has a significant impact on the human environment, which also includes cultural resources. So these acts have independent authority, but the processes that the government uses to fulfill their compliance with these acts often run together in tandem because you'll have projects that trigger both an HPA and NEPA, and they both need to satisfy their own review obligations. So the next slide is about NEPA analysis. NEPA is a wild beast at the moment. It is in flux in a way that is really remarkable. We have had the Trump administration, Trump 1, issued new NEPA regulations. Biden administration pulled those back. Then we had a couple of blockbuster court decisions in the last couple of years, including one that threw out the Council on Environmental Quality regulations completely, said that after 50 years of NEPA regulations, that the council never had the authority to issue them in the first place. So it has become the Wild West. And right now, we're in this very liminal space where agencies don't have a lot of guidance on what they should be doing to comply with NEPA. They're going back to the basics and looking at the law itself. CEQ has issued non-binding guidance to them and has told them all to come up with their own procedures, and that their own procedures have to be done within the next couple of weeks. So kind of wild right now. But what the law says is that whenever a federal agency is going to take a major action that significantly impacts the environment, it has to stop, analyze the effects, consider alternatives, and document that process. And usually from that, we get either an environmental assessment or a full environmental impact statement. Those are the documents that we're looking for to make sure that the agency complied with NEPA. And traditionally, we've had to have a lot of public consultation on a NEPA analysis, and it's a lot of public participation has been invited. The agencies would issue draft environmental assessments, public would comment, the agency would have to respond to those comments. Of course, we also have tribal consultation requirements. Those are currently being really narrowed down, and each agency has its own approach to how they're going to involve the public. So Wild West, but still the law. If you could go actually to the next slide, and then we'll come back to this one. Yeah, great. The way that NHPA compliance works on a federal undertaking is the government, the federal agency that's responsible for approving this project, has to consult with tribes and other interested parties. They have to go out and identify which historic properties might be impacted by the project. So, for example, I do a lot of work on transmission lines and pipelines that have to comply with NHPA. In those instances, you're going to look and see, okay, are there any archaeological sites that might be impacted by this construction? Are there visual impacts that could be had to historic properties that are in the way? Are we impacting a tribal cultural landscape? So historic properties is much broader than just an old building. It's any property that is eligible or listed on the National Register of Historic Places. So we have to go out, look and see which of these historic properties might be affected by this project. Once we have that list, the agency has to go out and figure out, well, how are they going to be affected? Is it going to be an adverse effect? And what can we expect the impacts to be? And then they consult with the public, with tribes, with states to figure out how are we going to resolve these adverse effects? Are we going to make design changes that would reduce them? Are we going to move the project to a different location? Are we going to create some sort of mitigation that will offset those adverse effects? So that's your normal Section 106 process. And now if you'll go to the previous slide, I just wanted to point out a couple of other...
the other direction.
The other direction. I wanted to point out a couple of other provisions in the National Historic Preservation Act that are relevant for these projects in DC right now. One of them is Section 110F, which applies when you have a National Historic Landmark So I said that historic property is a property that's eligible for or listed in the National Register. We also have a class of special buildings and properties that are on the National Historic Landmark List. And those get significantly more protection than just your regular historic property. We have about 2,800 NHLs in the United States. And Section 110F says that federal agencies, to the maximum extent possible, have to plan and act to minimize harm to these NHLs. So that's a heightened responsibility, and they have to consult with the National Park Service and invite the Advisory Council on Historic Preservation into that conversation. There's also 110K, which is a provision in the National Historic Preservation Act that's designed to prevent people from going out and just going ahead and removing those historic properties so that they don't have to deal with them when they go through the regulatory process. So when we've seen this in the past, it's been a developer tears down a historic school that's going to be in the pathway of a pipeline before they start the review process, so they don't ever have to mitigate it. They don't have to do anything about it later. It's called anticipatory demolition. So if a developer or somebody doing the undertaking goes out and harms a property with the intent to avoid the requirements, the penalty is that they should not be allowed any federal assistance. So if you're applying for that permit, the rule is you shouldn't get that permit because you've shown such bad faith, unless you can come to the agencies and work something out and show how you're going to make it right. So that's an important provision for our discussion today.
Thank you. Over to
Yeah.
Edwin. Turning to monuments and federal siting authority, what laws apply, particularly for ambitious, large-scale proposals like an arch? And where is their discretion?
Thanks, Nancy. And good afternoon, all. I have the fairly unique experience of actually having built a memorial in Washington, D.C. So I have become fairly familiar with the Commemorative Works Act, which was enacted in 1986 after debates over the creation, location, and design of the Vietnam Veterans Memorial and amid increasing pressures for new memorials in Washington. And the main purposes of the Commemorative Works Act are to preserve the integrity of the L'Enfant and Macmillan plans, to quote, preserve, protect, and maintain the limited amount of open space in the nation's capital, and to ensure that future commemorative works on federal land in Washington, quote, are appropriately designed, constructed, and located, and that they reflect a consensus of the lasting significance of the subjects involved. And the Act established a detailed multi-step process for approval, siting, and design of memorials on federal land in Washington. And helpfully, the Act, or specifically, the Act governs the creation of memorials in the District of Columbia and its environs, which is helpfully defined by reference to this map. Basically, that includes all federal land in the district proper, but it also includes GW Parkway from Key Bridge all the way down to Reagan National Airport, including Lady Bird Johnson Park, Monument Drive between the Memorial Bridge and the Arlington Cemetery, and the area around the Iwo Jima Memorial in Netherlands Carillon, and finally Gravely Point. Now, the statute says that no memorial can be built on federal property in the district or its environs without first receiving congressional authorization. So that's an initial, you ask about where is discretion, that's an initial hard hurdle to clear. Congress has to authorize placing a memorial anywhere on federal land in Washington and its environs, except with some exceptions that we'll get to later. Now, Congress can always, well, so that's the easy answer.
Right. Can we repeat that? Congress
Yeah.
needs to authorize.
Congress has to approve any memorial or monument that's going to go on federal land in the district and its environs. Pretty clear rule. And in considering proposed legislation to approve a memorial, Congress must consult with something called the National Capital Memorial Advisory Commission, which is a commission of commissions, and includes representatives of all the federal agencies with planning, design, and commemorative functions in Washington, as well as the office of the mayor of the district. Now, there's a second overlay to this rule, which is shown on the map here. Washington and its environs is further divided into three separate areas that each have separate rules. And the first is the reserve, and that's the area shaded in red here, or and bounded by the red line. And it's basically the cross axis of the mall from the Capitol to the Lincoln Memorial, east to west, and then from Lafayette Park down to the tidal basin, north to south. The reserve was defined in 2003 after Congress had declared that the mall is a substantially completed work of civic art and that there shall be no new monuments, memorials, museums, visitor centers, or anything like that in the reserve. Now, Congress, of course, can create exceptions to that, as it has done, for instance, for the Global War on Terror Memorial, which has been sited just north of the Lincoln Memorial across the street from the Desert Storm Memorial currently under construction. But that's the reserve. There's not supposed to be anything done there. Then there's Area 1, and that's the area bordered in the black line here. It encompasses the reserve. It includes the two triangles of land bounded by Maryland and Pennsylvania avenues. Goes up around Lafayette Square, and then it goes up past the Kennedy Center, across Key Bridge, and back down the GW Parkway to 14th Street Bridge and back over the river. And approval to locate a memorial within Area 1 requires a second congressional action. And so if a sponsor wants to be located in Area 1, it first has to persuade either the National Park Service or the GSA, whichever federal agency is the owner of that land, and the Secretary of Interior or the administrator of GSA then have to make a recommendation to Congress that the subject of the memorial is of such preeminent historical and lasting significance that it warrants a memorial within Area 1. They make that recommendation to Congress, which has 150 days to approve it by a subsequent act. So there's a two-step congressional process to get into Area 1. First, authorization of the memorial in the first place, and then a second determination to go into Area 1. And then finally, there's the rest of the district, which is Area 2, which has no special rules other than those that are included in other than the basic requirement of congressional authorization for a memorial. There are a few other procedural requirements that a sponsor must meet before obtaining a construction permit, but those are a little too far in the weeds for this presentation, and they aren't subject of dispute in the Arch case. But that's the basic framework.
Okay.
And so again, there are two. Well, and then I'm sorry, I left out a key part. So once a memorial is authorized and a sponsor is designated to build the memorial, the sponsor has to go back to NCMAC and consult with NCMAC regarding site selection and design concepts. Ultimately, both the National Capital Planning Commission and the Commission of Fine Arts have to approve the site location, and they have to approve the final design. Typically, the design review process is a long, iterative one, measured in years, involving multiple submissions to the two agencies. The agencies generally first approve a design concept and then review and comment on several iterative refinements of that design concept until a final design is approved. Suffice it to say, that process typically takes longer than it has taken with respect to the White House Ballroom or the Arch to date. Those design review processes have proceeded quite expeditiously. But that's the general framework for new memorials and monuments.
Got you. Thank you. So we're covering a lot of ground pretty quickly, which we'll break up into the specific disputes soon. But Marion, is there anything else you want to add, recognizing that DC is not a state, but a federal city? We've heard a couple of acronyms floating by, as you do in Washington, but anything that you want to add to that? You're muted.
Yeah, real quickly, Edwin mentioned the National Capital Planning Commission. That is the federal government's central planning agency for the National Capital Region. And they're supposed to kind of oversee the development of federal property in and around Washington. They prepare the comprehensive plan for the national capital. And that's the plan that's supposed to govern how federal buildings, landscapes, infrastructure are designed, sited, developed. And so they use that plan to evaluate individual project submissions. And for federal projects on federally owned land within DC, they approve the project's location, the height, the bulk, the number of stories, size, open space provisions. So federal government has to come to NCPC for a review of these projects. Edwin also mentioned the Commission of Fine Arts. That's an independent federal agency that has experts appointed in architecture, art, design, and their role is to advise on the aesthetic and the artistic dimensions of federal construction. So before the federal agency can finalize plans for a public building or a structure that affects the appearance of the city, they submit those plans to CFA for review and comment. CFA is advisory for those projects, but traditionally their input has been critical to improving projects and making sure that the dignity of the capital's civic environment is preserved for the public experience.
Thank you. All right, Emily, bring us home. What constitutional clauses are more relevant here and doctrines in administrative law?
Thanks, Nancy. So I'm going to talk about so next slide, please. I'm going to talk about the bedrock law underpinning much of the conversation that have already had and are going to have going forward today, starting with the Constitution, which is the basis for everything that we're studying here. Lots of y'all are law students. You get that. So the real key with the Constitution that applies to all of these cases is the idea of a balance of power between three co-equal branches of government. So you have Article 1, Section 1, which vests all legislative powers in the Congress of the United States. You've got Article 2, Section 3, which charges the president and the executive branch with taking care that the laws shall be faithfully executed. And then you have Article 3, Section 2, which gives the federal courts the authority over cases arising under the Constitution, the laws of the U.S., and in any case where the United States is a party, and a whole laundry list of other things. But those are the things that are really relevant here. The idea here being that all of these branches of government both work together and also counterbalance each other so that there's constant evaluation and reevaluation of government action. And as part of its lawmaking authority, Congress has passed a large body of law regarding how government agencies should operate in their public mission. For example, next slide, the Administrative Procedure Act. The Administrative Procedure Act governs executive branch agencies and how they interact with themselves, with interagency actions, and also with the public. And it requires the agencies provide notice and comment periods for agency actions, which is really, really key to a lot of what we're going to discuss today. And it also provides the process for judicial review. So Section 702 says that cases can be brought by any individual or entity who is suffering a legal wrong because of an agency action. And the broader text here is there on your screen if you want to read it. It also allows the reviewing court to compel agency action, which has been unlawfully withheld or unreasonably delayed. So if an agency isn't doing something that they are supposed to do, for example, having notice and comment, then 706(1) requires them, allows the court to compel them to do so. And if an agency action has been arbitrary and capricious, then 706(2) of the Administrative Procedure Act allows the reviewing court to hold such action unlawful and set aside that agency action. So all of these have come up in various ways in the cases that we are going to start to discuss in just a minute or so here. So, one final concept that we need to discuss, next slide, is the common law concept of ultra vires, which I probably just mangled. It's Latin for beyond the powers, and it is a concept that describes when an agency or other entity is acting outside of its authority. And it is invoked in this context when agencies or other governmental entities are acting outside the legislative intent that Congress set forth. So when you have an executive branch that is acting outside of the authority that was given to it by the legislative branch through the laws that were passed. And this is another concept which provides the basis for a lot of the cases that we're discussing today. So all of these concepts, all of these laws are supposed to be working together to ensure that there's accountability for governmental action, ideally without us having to bring lawsuits, but we are where we are. So each branch of government is supposed to have its own sphere of authority to take action and enforce a balance of power between all three. Ideally, the government is holding itself accountable between the executive and the legislative branches, but people and organizations who are harmed can bring lawsuits, as just discussed, and anyone who has a specific interest in any of these things can provide notice and comment when such is offered, or you can contact your legislators to keep pressure on issues that you care about.
Okay. All right. So we've gone through a lot of law. Let's test these legal frameworks against the situations that we set out at the beginning. So the first, next slide, involves the monumental arch proposal. It's forward-looking, new monumental construction within one of the most tightly regulated landscapes in the country. Edwin, what are the facts here?
So since he returned to office, the president has on a number of occasions stated plans to build a ceremonial arch on Memorial Circle at the western end of Memorial Bridge, between the bridge and the entrance to Arlington Cemetery. And presumably the arch would be modeled in large part after the Arc de Triomphe in Paris. But of course, it's a common architectural form found in numerous countries throughout the world in numerous periods of history. These are two American arches. On the left is the arch in Washington Square in Manhattan. On the right is the Soldiers and Sailors Memorial Arch, which is a Civil War memorial in Brooklyn. Now, both of those arches are about 80 feet high, top to bottom, not counting the statue known as a quadriga on top of the one to the right. So bear that in mind, about 80 feet high. So go to the next one, please. So on April 16, the latest renderings of the president's proposed arch were presented to the Commission of Fine Arts, which gave its approval to the underlying design concept. The top of this arch, just to the flat top of the arch, not counting the sculpture on top, would be 166 feet high. So more than twice as tall as those other arches that we just looked at. On top of the arch itself would be a sort of pyramidal platform, on top of which would be a 60-foot tall sculpture that appears to be a mashup of the Statue of Liberty and Winged Victory. The entire thing would top out at 250 feet to correspond to the 250th anniversary of American independence. We can go to the next slide. This is a graphic that shows how high the work would be relative to other Washington landmarks. It would be close to half as high as the Washington Monument, which is 555 feet. Compare the 166 feet to the top of the arch proper to a Lincoln Memorial, which is just under 100 feet. And the entire thing would almost rise as high as the Statue of Freedom on top of the Capitol Dome. So it would be large. I need to make a detour here. I should have said at the outset, because I'm a federal employee, I'm here speaking in my individual capacity. I am not speaking for my agency or the government. My goal is to refrain from expressing opinions, but any opinions that I do express are mine only and not those of the federal government.
Thank you.
Go back to the prior slide if you could, Tanyat. Other way. Other way.
Oop.
Hard time going backward.
Yeah.
Anyway, at the 4 points of the arch are proposed to be sculptures of 4 lions, based on either the The lions at New York Public Library, or perhaps the lions around, next slide. The lions are around Nelson's Column in Trafalgar Square in London. At least one member of the Commission of Fine Arts has suggested that perhaps since the lion is not native to the United States, they could be replaced by a bison or other animals that are native to America. All right, next slide. One after that. This shows the location. The arch is what's indicated in gold in the center of this rendering, this photograph here. As I say, it's at Memorial Circle at the western end of Memorial Bridge, interposed between the Lincoln Memorial to the east and Arlington House at the top of the hill, at Arlington Cemetery to the right, or to the west. Arlington House is also known as Custis Lee Mansion. It was owned by the Custis family, into which General Robert E. Lee married, and so the house is associated with him. Memorial Bridge itself was conceived when it was built in the 1920s as a symbol of national reconciliation between North and South after the Civil War, and also as a ceremonial approach to Arlington National Cemetery. And this triumphal arch would be inserted into that ceremonial roadway and the view shed. And go to the next slide. These are the view sheds looking across Memorial Bridge. This is looking from the Lincoln Memorial west to Arlington National Cemetery and Arlington House at the top of the hill. The new arch would rise 250 feet at the far end of the bridge. And then the next slide. This is looking back in the other direction, eastward across Memorial Bridge. The arch would be built on that grassy area in the center of the photograph, which is Memorial Circle. A group of military veterans, along with an architectural scholar, have brought suit to enjoin construction of the arch, asserting that it disturbs the view sheds and the symbolic connections between the Lincoln Memorial and the cemetery in Arlington House. The court has issued a consent order dismissing the plaintiff's preliminary injunction motion without prejudice, based on the National Park Service's stipulation that it would not initiate or authorize initiation of construction without going through certain statutory review processes, including those under Section 106 of the Preservation Act and NEPA, as well as an Endangered Species Act and some FAA regulations. They've also stipulated that they won't do anything without 14 days notice posted on the court's docket. So this is not a case where bulldozers might show up tomorrow. And the case is in a very early stage. No merits ruling has been issued at this point.
So let's just to help us understand that. So how has the Commemorative Works Act fit into this discussion?
So the act would not prohibit construction of the arch outright, but plaintiff's case is that construction of this memorial, that it's a commemorative work that would come under the act, and that therefore the act imposes those various procedural requirements that the president hasn't met, that I talked about, and that therefore no construction can proceed unless and until those steps have been cleared. Principally, plaintiffs argue that the arch can't be built without authorization from Congress, which Congress has not given and the president has not requested. If Congress were to authorize construction of an arch at this site, or for authorized construction of an arch, then there would have to be a determination by the Park Service that Area 1 is warranted, and go to Congress to make that recommendation, which Congress would have to act on. Now, Congress could wrap all that into one act and say, we approve the construction of an arch and we approve it in Area 1 and we specify that it will be built at Memorial Circle, and short circuit some of the usual site selection process, which can take a year or so in other cases. But essentially, Congress would have to make those various determinations before the president could proceed. At that point, the president would then have to go through design review and approval by the NCPC and the Commission of Fine Arts. Commission of Fine Arts has already approved the design concept for the arch. I don't think the NCPC has taken it up yet. but they would have to go through those processes. Now, strictly speaking, in considering location and design review, the agencies are supposed to consider are supposed to determine that the commemorative work be located so that it does not interfere with or encroach on an existing commemorative work, which would include the Lincoln Memorial, obviously, as well as Memorial Bridge, and that to the maximum extent practicable, it protects open space, existing public use, and cultural natural resources. That comes out of the Commemorative Works Act. But it only says that the CFA and the Planning Commission shall be guided by, but not limited by, those criteria. So it's something that they have to consider, but they're not binding constraints. So the real gatekeeper here would be Congress. But this all assumes that the Commemorative Works Act applies. And there's a couple interesting arguments here that the government has raised. Clearly, the site is within the district and its environs, so that's not an issue. The government seems to be holding on to the argument that the arch is not a commemorative work and that it doesn't therefore fall within the Commemorative Works Act. There's not, to my knowledge, been an official statement of what the symbolic meaning of the arch is. I've seen it referred to as the Independence Arch, or more generically, a triumphal arch. And that begs the question of what triumph is being celebrated. So perhaps it's a war memorial writ large, or it's taken as the triumph of American democracy. What's interesting is that in its brief opposing the preliminary injunction motion, the government did not say what the symbolic purpose of the arch would be. The Commemorative Works Act defines a commemorative work as a feature, quote, designed to perpetuate in a permanent manner the memory of an individual group, event, or other significant element of American history. And so the plaintiffs would argue that self-evidently this is a commemorative work that falls under the act, but the government seems to be holding on to an argument that it's not.
Interesting.
So that's an open issue.
Okay.
Now, the plaintiffs also, a second issue is the grandfather clause in the Commemorative Works Act. It states that it does not apply to commemorative works that had been approved prior to the passage of the act in 1986. The government has gone back to legislation from the 1920s involving the Memorial Bridge Commission. And the commission had submitted to Congress a design for Memorial Bridge that included 2 columns at the western end of the bridge. Congress blessed that design, gave the commission authority to execute it, along with such other revisions it might deem proper. Obviously, the commission built the bridge, completed it to all appearances in the late 20s, early 30s. That commission was sunsetted. Its remaining responsibilities were transferred to the office that ultimately became the National Park Service by executive order in 1933. So the government has asserted that that authorization to construct those columns or otherwise make revisions to the approved plan still survives, notwithstanding the completion of the bridge almost 100 years ago and the expiration of that commission, that it can rely on those still. So that's a matter open for debate, and the defendants will be arguing that they are not subject to the Commemorative Works Act. Now, there's another statute that I'll confess I only learned about preparing for this seminar, and thanks to some of the briefs I read in the other cases, and it's going to come up with respect to the White House ballroom. But 40 U.S.C. 8106 says quite simply that buildings shall not be erected on any federal property in the District of Columbia without express authority of Congress. Pretty plainly stated restriction. Again, the government is finding a variety of ways to argue around it that may come up in the discussion of the ballroom. The one wrinkle, 2 wrinkles here. One is Memorial Circle. It doesn't talk about the district and its environs. It just talks about the District of Columbia. But Memorial Circle sits on Columbia Island, which is entirely within the Potomac River. And the district line extends all the way to the Virginia shore of the Potomac River. So yes, it does fall within the District of Columbia, even though it looks like it's over on the Virginia side. But then the president also asserts that that same 1925 statute regarding Memorial Bridge also exempts it from 40 USC 8106. So that's another issue that will be debated.
Okay. All right. A lot to cover. Lightning round. Marion, assuming you get through all of these other issues, how does the National Historic Preservation Act and NEPA operate here? Are they
Right.
just
Like they would have to go through both of those processes, invite public comment. You've got NHLs all around that have to be considered in the construction of this. And you have a full cultural landscape there. I mean, the sight lines I think are really important because you have the Lincoln Memorial on one side and you've got Estes House on the other, and this whole landscape is supposed to signify the reunification of the country after the Civil War. So now you're interrupting it with this arch that still don't know what the symbolic meaning of the arch is. So how would that fit into the landscape? So yes, both of those processes would have to be completed, assuming that there was actual authorization to do the project.
And I'd say, and those apply anyway, regardless of whether the arch is subject to the Commemorative Works Act, regardless of whether it's subject to Section 8106. NEPA and NHPA and some other statutes are going to apply regardless, because it's obviously property having or a project having an adverse effect on a historic resource, Memorial Circle itself. It affects the adjacent National Historic Landmarks. And as I read the record, the government has stipulated that those processes will be followed. So suffice it to say, there's not going to be an arch there by July 4th of this year.
Okay. Anything else? Emily.
So I was just going to note that there's an inherent participatory element to all of this with any kind of monument or memorial. And Edwin had great photos of people walking through the space. Like, it's a gathering space for people. It's a place where you're constantly seeing people walk through and to experience the parks, to experience Arlington Cemetery, to experience the walk across the bridge. And monuments and memorials are really inherently participatory. They exist as a means of governmental expression, and of what is valuable, what is worthy of memorializing. And they become strong cultural touch points. They also become a loci of individual and community expression. I mean, there's a reason why they tend to be gathering places and sites of First Amendment activity. These things happen. There's speeches at the Lincoln Memorial all the time because the memorial itself is important. And that location and that sense of place is vital to how we as a community, and by that I mean a nation, experience these memorials and monuments that are meant to commemorate important things to us as a culture, as a country. So any kind of, whether you're building a new memorial or, tearing down a piece of public, something built on public space, it all has an effect on the underlying community and the conversations that people are having.
Great. Okay. All right. Our next situation, anything more, Marion? Otherwise, I'm going on to our next situation, which is the White House. The East Wing, a site that is symbolically central, but legally unusual, given its status in the executive complex. So maybe you can lead us through our look at this situation.
Yeah, I'll give a brief overview of kind of what's happened, and then we can talk about the weirdness of the legal frameworks for the White House. So last July, the White House announced plans to construct this 90,000 square foot ballroom next to the White House. And the chief of staff initially said, we're going to go through all of the required legal processes. Don't worry about it. But there were no plans that were ever submitted to NCPC, the Commission of Fine Arts, or Congress. We didn't see any plans for the ballroom. And then out of the blue, I'm sure you all remember in October, the bulldozers went in and started pulling down the east wing of the White House. We had been told by the president that the east wing would not be touched. It has been completely demolished. There was no prior review, no opportunity for the public to comment, no notice to anybody. And within days, the entire east wing was taken down. The commemorative trees were taken down. All the entire area, which you can see here, is just obliterated, right? They took the debris and dumped it in a nearby public golf course without any review of the environmental impacts of doing so. And so then the National Trust for Historic Preservation decided to file suit in December. That they at that time we had active construction underway at the site. They had started trying to build out the underground under the ballroom, and there had been zero weigh-in from our elected representatives or any of the review commissions that are required to review the project. So the National Trust sued, asking for a temporary restraining order, preliminary injunction. And where it stands now, which as of Friday, the district court judge had issued a preliminary injunction stopping construction of the project. That injunction has been stayed until June 5th, when we'll have oral argument in the case. So as of Friday, the president is allowed to continue his construction project above ground and below ground through the early June. And then we'll get an oral argument for the DC Circuit of Appeals, and we'll see what they do.
Mm-hmm. And do you feel that this is affected by the presence of the highly secured site? You know, what do you think is
so part of the argument here is that they're building a highly secure bunker underneath the ballroom. It's going to have like its own data center and medical equipment and all kinds of high security features for national security. There was a bunker before underneath that has been known. So now they're trying to say that the entire ballroom must be built as a matter of national security, because you can't have a hole in the ground next to the White House and leave it open, because that creates a security risk for the president. And they're trying to bootstrap the fact that the ballroom will have security features like bulletproof glass, say that it must be built now. I appreciated Judge Leon last week when he clarified his injunction order. He said, I am not going to be dragooned into becoming a construction manager of this project. He said, it was going to be months and months before you had the ballroom constructed anyway. You don't have to, there's no urgency here to build a ballroom for its security features. And that judge felt that there was certainly an ability for the project to be stopped and paused at this point. The judge, in that case, the plaintiffs alleged a lot of legal failings of this whole process. Of course, we had no public notice, no NEPA review. What's odd about the White House is it is exempted from the National Historic Preservation Act. The Section 107 of the NHPA says that none of the act applies to the White House grounds, the Capitol, or the Supreme Court. And that was inserted as a separation of powers situation. Like, you don't want Congress telling the justices of the Supreme Court that they can't make changes to the bathrooms at the Supreme Court. So it made sense at the time. I don't think anyone envisioned that a president would unilaterally destroy part of the White House without telling anybody he was going to do that, or giving anyone a chance to weigh in. But that's where we are. The judge was most persuaded by the fact that there has been no congressional authorization for this project. And so that's what Judge Leon decided. The plaintiffs were most likely to win on the merits. And he instructed the president to go to Congress and get some approval before continuing this project.
Mm-hmm. And if what is actually happening on the ground? I mean, if the plaintiffs win, what is the remedy?
So Judge Leon said, you can, if you want to keep constructing, like he had said, he gave them 2 weeks to wrap up the construction before his injunction would have gone into effect. He said, go ahead, but if it's not for national security, you're going to have to rip it down.
Mm-hmm.
So there is a chance that the new construction could be required to be undone, but there's no remedy that would force reconstruction of the East Wing if that were even possible at this point.
Mm-hmm. One other just aspect to the litigation, there seems to be some discussion of the relationship between the White House and the National Park Service with respect to Presidential Park in the White House. And how does that work?
Yes. The White House is actually part of a national park, President's Park, and the Park Service has traditionally managed that area. They've done the master planning for the White House and the Visitor Center, and NPS has been responsible for various maintenance activities and management. What's weird about this ballroom case, and it's also happening in a couple of the other cases, is that they're playing a game of pass the buck and trying to find entities that can be responsible for the project that do not qualify as federal agencies. So in the ballroom litigation, the government has given conflicting answers to the judge about who's in charge. Sometimes the Park Service is in charge of this project, which is a federal agency subject to NEPA and NHPA. Other times it's the Executive Office of the President that's in charge, which is not a federal agency and is not reviewable under the Administrative Procedure Act. So it's very unclear who is calling the shots, except to say that obviously the president is calling them. Who's receiving them and executing them is very murky in these projects right now.
Got it. I think our next few slides are pictures that I've just put in from my personal collection, but you're welcome to go through them, Tanya. I can explain.
Oh no, please, please do. Show these cool pictures.
Right. This is actually the suffragists demanding the right to vote outside the East Wing entrance, as the picture reflects. If you go to the next slide, this is the entrance to the East Wing. Next slide. This is a before and after picture of the Rose Garden, Jacqueline Kennedy's Rose Garden. And next slide. This just shows the part of the East Wing. On the left, it's the looking out into the Rose Garden. On the right, looking at the entrance to the East Wing of the White House. So you get a sense of what is lost, and this is a picture of the proposed ballroom. So another one that is underway, and we'll see. It seems that every single day we're seeing another an opinion or an article about.
Yes, and all of these laws that we're talking about, that they layer over each other in different ways on different projects in DC. But they're all designed to create a situation where you have members of the public and their elected representatives weighing in on what happens, because we own these properties. They are not owned by the president. And all of these cases are exposing ways that the president is trying to get around having to hear from us about what our opinions are about these projects. So I think it's really important. It gets very technical. wading through these court filings. But at the core, that's what it's about. It's about we the people having a voice in what's happening in our name, and to the places that we care about in DC.
Right. I see we're here on the claims. I think you've covered this. So why don't we go to our next situation involving the Kennedy Center. So in there, we see alongside questions about institutional governance, we're also talking about physical redesign or modeling or of a space. So maybe Emily, someone who's the Kennedy Center is near and dear to her heart, can talk a little bit about what is going on there.
Absolutely. Thanks, Nancy. So, I mean, there's been really two key things relevant. So, go back. Well, thank you. Yeah, you can actually go back to the original, or go back 1, 2 now. Okay, that's great. So there's basically key things happening right now at the Kennedy Center. There's a lot going on, but relevant to our discussion, there's the impending closure for renovations, which the president announced to be a Truth Social post. So that's the next slide. That is planned for 2 years, beginning this July. And then there's the ongoing controversy regarding the Board of Trustees and the limit or reach of that board's power and authority, which includes both the approval of the planned renovation and also the renaming of the institution, among other things. So next slide. So to understand how all of this plays together, you have to understand kind of what the Kennedy Center is. So the John F. Kennedy Center for the Performing Arts is the National Cultural Center created by Congress, but it is also a living memorial to John F. Kennedy. And per the John F. Kennedy Center Act, it is the sole national memorial to the late John Fitzgerald Kennedy within the city of Washington and its environs. There's that language that Edwin was using earlier about, the space in which the Kennedy Center has, I guess, exclusivity, we'll say. This is important because by definition, the art that is presented at the Kennedy Center is part of it, as part of its legislative mandate, is part of that living memorial to John F. Kennedy. And so, the memorial is not just, the Burke's bust that you could see in the previous slide, or the interpretive exhibits, or the carvings on the outside of the marble. It is also every work of art that is performed, that is shown, that appears within the Kennedy Center and its walls becomes part of that memorial to a slain president who deeply, deeply valued the arts as part of American life. So if the Kennedy Center is closed for any extensive period of time, it's not just that the building is closed, it's that this memorial essentially effectively ceases to exist in the way that Congress intended. So, DC obviously loses what has historically been an absolutely vital backbone of our local arts and cultural scene, but the entire nation is cut off from that memorial to Kennedy that Congress created. So from a governance perspective, this gets really complicated. And, the Kennedy Center is not any one thing. It's a federal entity. It's created by an act of Congress. It's a bureau of the Smithsonian, but it's not actually managed or governed by the Smithsonian. It has its own board of trustees and its own governance structure. It receives federal appropriations to maintain the facility as a memorial, but all of the art that the Kennedy Center presents is paid for through non-appropriated funds. So it's all paid for through trust funds. It's also how most of the employees are paid, which I just mentioned kind of as a footnote because people always wonder that. And the Kennedy Center Board of Trustees is made up of a mix of ex officio trustees who are trustees by virtue of their office, which includes a number of cabinet officials, the Secretary of the Smithsonian, the chair of the Commission of Fine Arts, and congressional representatives, like, for example, Congresswoman Joyce Beatty, among a number of others. And then there are the general trustees that are appointed by the president, who in normal times would be a mix of trustees that were appointed by both the current sitting president and the prior president. And because they all serve 6-year terms, there's sort of 3 different classes. So it's all structured so that in theory, the Kennedy Center always has a mix of trustees appointed by more than one president. So a multiplicity of viewpoints. That obviously is not the case at the Kennedy Center right now. And so unlike a traditional private performing arts center, the Kennedy Center's ultimate governing authority is not its bylaws, it's not articles of incorporation. It is technically, it's not incorporated under the laws of any state. It's created by an act of Congress. And so it is that founding legislation. It is the John F. Kennedy Center Act that provides the underlying backbone of what the board's authority has and how the institution is governed. And a lot of Congresswoman Beatty's lawsuit really turns on those questions of what does Congress authorize the Kennedy Center board to do? Does the Kennedy Center Board of Trustees have the authority to change the name of an institution that was named by Congress in its authorizing legislation? Does the Kennedy Center Board have the authority to authorize the addition of Donald Trump's name to a building where its legislation specifically prohibits the addition of any additional memorials or plaques in the nature of memorials in the public areas of the center? Does the board have the authority to close an institution that was established and directed to operate by Congress? So there are real and legitimate questions of whether the board's actions are in compliance with the Kennedy Center's own legislation, let alone other federal law that might be applicable. So that's kind of the governance overview before I think we're kicking it now to Marian to talk about the preservation overview.
Just before we get to Marian,
Okay.
Edwin, just a quick question. What is this repurposing of memorials? Any restrictions? Any history?
Well, I mean, it's interesting. There's a statute here that says, 76J, that says no additional memorials or plaques in the nature of memorial shall be designated or installed in the public areas of the Kennedy Center. That does call into a question, the legality of adding his name to the center.
Mm-hmm.
There's no statutory prohibition per se against repurposing memorials, but the consistent position of the National Capital Memorial Advisory Commission has been against that. In fact, just last month, the NCMAC took up a bill that would essentially co-designate Memorial Bridge itself, which we've talked about, as a memorial to the Mexican-American War of 1848. And the NCMAC was opposed to that on that ground, that it was designed, built, and conceived as a Civil War memorial of sorts, as a symbol of national reconciliation. Adding new meaning to it would be improper. At one point, there was a proposal to take the DC War Memorial on the National Mall and expand it and give it a national memorial character over and above its local memorial character. And the NCMAC was opposed to that. So there is a consistent line of thought that once a memorial is conceived and built with a specific commemorative intent, that ought not to be tampered with down the road.
Thank you. All right, Marian, to what extent do statutes like the National Historic Preservation Act and NEPA, the Environmental Policy Act, meaningfully constrain remodeling of a site like the Kennedy Center?
Thanks, Nancy. So before I go on, I should say my firm is counsel for plaintiffs in a lawsuit over the Kennedy Center, along with 2 other law firms, Foley Hoag and Lowell and Associates. We represent the DC Preservation League and 7 other major architectural and historic preservation organizations. And whereas the Congresswoman's lawsuit includes governance claims, we're really focused just on the historic preservation concerns. So we are arguing that when the Kennedy Center board changed the name of the Kennedy Center and changed the sign out front and then proceeded to paint 200 gold columns white. That was a federal undertaking that should have triggered Section 106 review. They did not do that review. So we're arguing that they have violated that anticipatory demolition clause that I mentioned earlier. And so they should not be allowed a permit at all for this project. They also have to do National Environmental Policy Act review, a NEPA review for this project. They would need to submit it to NCPC. They would need to submit it to CFA. But the trigger there, they can't do anything until Congress gives them the authority to do so. And in previous expansions at the Kennedy Center, when they needed to add new parking, when they constructed the Reach, Congress expressly authorized those projects. And so we're also arguing that the underlying statute that set up the Kennedy Center does not allow the board to make these huge decisions unilaterally. Congress really needs to weigh in here.
Okay. All right. All right, let's just move on to our last situation.
Yeah, we got so much to talk about and so little time. Yeah.
We have so little time, so many things, and we are getting some very good questions and want to leave time for that as well. All right. So the Eisenhower, anything more with the Kennedy Center? Okay.
Nothing more on the Kennedy Center. And I will give you a super quick overview of the EEOB case and how it compares to these other cases.
Oh, go back.
So back in November, President Trump gave an interview with Laura Ingraham on Fox and started showing pictures of the Eisenhower Executive Office building, which is the building right next to the White House that houses a lot of the White House staff. He showed these pictures of it painted white and said that he was already contracting with painters to come in and paint the building. And our firm got very concerned. The DC Preservation League got very concerned. So we filed suit to stop that project until such time as the appropriate reviews could be carried out. The government has agreed not to do the project until some of those reviews were completed. And then they changed gears and decided that while normally the General Services Administration would be in charge of painting this building, they were going to delegate GSA's authority to the Executive Office of the President and the Office of Administration within that office. And the Office of Administration is not a federal agency subject to NEPA or NHPA. So it's this real sleight of hand designed to cut the public out, to get them out of having to go through these consultation processes. And so now the government is saying they're going to voluntarily comply with NEPA and NHPA. But if OA is not a federal agency, we have no way to hold them accountable for that. So we're waiting. We just had a motion to dismiss and reply filed. We're waiting for the judge's decision on that. But I think it's really important because I'm concerned that this is a blueprint that the government is going to use on any project. So the next time I'm working on a big pipeline project and they're trying to cut out tribes or it's getting messy, is the president going to say, oh, FERC doesn't regulate that anymore. That's just an Executive Office of the President pipeline now. Goodbye. That's what we're concerned about.
Why would the White House office not be constrained? This is as a matter of principle and agency. You can't delegate authority you don't have. And so,
right. So Congress gave
but it would seem to me that if the GSA delegates authority down, the constraints travel with it because it's delegated authority. It's not authority inherent in the White House.
Well, and Congress gave this authority to GSA and told GSA they could only delegate it to another federal agency. So we are arguing that the delegation itself is unlawful.
Okay. All right. So we have 4 situations. Beautiful picture of the EEOB. Next one. Is that a rendition?
Yeah, that's what it would look like, supposedly painted white. One of the big concerns here, like painting granite building will destroy the building. You'll have to abrade the granite. You will the paint will not adhere. So pretty soon we're going to have a peeling white executive office building that has to be repainted constantly. Like the Golden Gate Bridge is always having to be painted. This will constantly have scaffolding in front of it. It will be constantly having to be repainted because then, as we all know, and is written in the Secretary of the Interior standards for rehabilitation of historic buildings, you do not paint masonry. Just don't. So they're trying to go against a longstanding historic preservation practice, and we're concerned about it affecting the structure, constitutional structure of the building.
Okay. These are just, I just threw in a couple of pictures of this beautiful building. All right, so we've gone through 4 situations. I think let's go past this, if that's okay. And just do some comparison across all the scenarios, because a question I have for you is, are these statutes functioning as constraints or as tools for structuring negotiation, delay, redesign? How is this playing out?
So they're process laws, like NHPA and NEPA are process laws, but the process is there to make the project better. So if the process is functioning, you're getting public comment, you're responding to it, you're tinkering with the design to make it better. What we saw, for example, the Arch and the EEOB came before the Commission on Fine Arts last week. They got over 1,000 comments on the Arch, over 900 on the EEOB from the public. All were opposed to the project, and the commissioners still approved them and didn't respond at all to those public opposition. So that's not a functioning process at all. And our public comment is not having the desired effect.
So I'm struck by a question that was forwarded by in our comments, which is, I am impressed by the many levels of careful review required for altering or adding to the landscape of the nation's capital. Based on these unprecedented and dramatic deviations from the stewardship of the landmarks, do our panelists have any recommendations for ensuring that no future, let alone doing something right now, that no future rogue actor can destroy the preservation of these types of sites? Are we learning from this?
All your congressmen, please.
Yeah,
I know that
should-
members of Congress are looking at ways to strengthen these laws because they're being exploited in ways that were never anticipated by the people who originally wrote them.
Yeah.
each of these cases presents a wrinkle of one kind or another. You know, the question of whether the Kennedy Center is an agency bound by certain of these laws. And so those wrinkles could be smoothed out legislatively, but that would take some work, and it's not going to happen soon.
So then I guess the question is, let me ask you a couple more factual ones here. In my research on the congressional record, it looked as though Congress also exempted the White House and the Supreme Court from Section 107. I think that was mentioned because these buildings already had preservation associations and their own funds. Has anyone else done deeper research into the congressional record with respect to the disputes?
Would love to see what you've found. Please send it to me.
Too.
Because what we have found, what we found so far was more of a discussion of trying to maintain the separation of powers as the thinking behind the Section 107 exemption. But certainly would love to see whatever you've turned up.
Yeah. We're open for questions. How about the Code of Historic Property for the U.S. that approximates cultural heritage laws in other source nations? I feel like part of the issue is that there's a lot of process, and again, creating space. And some of the issues is the enforceability of when things go awry, which is really what we're discussing here. What else?
I'll
Emily,
mention things are still very much in flux. The Advisory Council on Historic Preservation is getting ready to rewrite the Section 106 regulations. As I mentioned at the top, NEPA is a huge question mark at this point, how each agency is going to enforce it. I would expect lots more litigation on both of these statutes. And I'm hoping that this whole exercise will prompt a rethink of Congress about what we really want to accomplish with these laws, and what kind of hardcore protections could we put into federal law. Because right now, historic preservation law is at the federal level is process. At the local level, in a lot of communities, there's real approval authority and real protection authority, but the federal laws don't do that. They just set up a process where the public gets to weigh in, and that requires good faith from all of the actors who are participating in those consultations.
yeah. And certainly, as you've said before, there are also a lot there in DC. Congress has a large role here, and so also has the ability to weigh in at different times. Yeah,
I think that's the point here, is that the president could conceivably accomplish all of these things. And the suits are not necessarily to stop them altogether, but to put them into a process that, as Marion says, was designed to bring in voice of the public, bring in expertise from applicable disciplines, to bring in historical perspective and context, to shape those decisions and ultimately make the project better.
Yeah. Emily, I think there was a question directed to you, if you want to read it and respond to it.
I'm not seeing one that was specific to me, but I am happy to tackle one if you
Sure.
like to.
On the Kennedy Center.
Yeah, I mean, there's been a handful of questions about the Kennedy Center in terms of I mean, I'm probably not the best one. I answered the First Amendment question in the chat, so check on there. But in terms of I think Rebecca in the Q&A is correct that the gold columns and the willow trees are features of the original plans for the center. That they're not arbitrary, they're not just random design decisions. And I mean, Marion can probably speak to the specifics of 106 here more than I can, but I mean, I know that when I look at the Kennedy Center now, it looks wrong because the entire design is based in part upon the idea of these columns that are visibly holding up and maintaining the structure. And there is meaning, and I apologize, I forget exactly what the significance is, but there is actually significance to the number of columns around the building. I mean, it's not arbitrary. And so by rendering those columns effectively invisible, you eliminate a significant aspect of that design. And it's also important to note that there's not a lot of great examples of really high quality modernist architecture within the District of Columbia. There's a lot of very brutalist architecture, but there's not a lot of really elegant designed modernism. And the Kennedy Center is one of the best examples of that within DC. And so that's why preserving it in its actual, in its original visual architecture is so important. And it's not just important to the Kennedy Center, it's important to all of those other, protected spaces and landmarks that have the Kennedy Center within its sightline. So the view shed from Roosevelt Island, from the Lincoln Memorial, from all of these other historic places that are unquestioned, even if you want to argue it's not registered, it's over 50 years old and it's a memorial. It's pretty clear, the statute's pretty clear that whether they bother to actually register it or not, the Kennedy Center falls into the realm of 106. And, that is, so, but even if you could colorably argue that the Kennedy Center itself is not subject to it, there are half a dozen to a dozen other landmarks within the district that are unquestionably protected, that any exterior physical change to the Kennedy Center changes that view shed. And that was a really important part of the conversation when, the Kennedy Center was going through NCPC and CFA review for the REACH project. And that's part of why so much of that is built underground, so that it doesn't affect the sight lines and, and doesn't affect the view of the Kennedy Center itself, of which those gold columns and those willow trees were a key aspect.
Thank you. So, in our last couple of minutes, I'd really love to just ask you, we've talked about a lot of these laws. What do you think are the single biggest misconceptions about them governing these disputes, and what people should know? I think Emily gave us a first start of that. But I wonder, Marian or Edwin.
I think I'll just reiterate, like, they're process laws, but they're not there just to check the box to move forward. They are designed to make the project better, and to give real deliberation to decisions that will have a huge impact for a very long time. So we talk a lot about these laws in the context of permitting reform and how fast can we get these energy projects permitted? How fast can we build these data centers? And it's really at its core, it's about public participation and people having a voice in our democracy as to what the federal government's going to be doing in their backyard. And DC is everybody's backyard. So we all really need to weigh in. And when we do get process, when we do have the opportunity to comment, even though it seems somewhat futile when the president has stacked these review boards with his own secretaries, it's really important to build the record of what the public thinks about these projects. And so I hope everybody will take the time to participate when there's an opportunity.
Thank you. As Professor Christine Farley says, why do you suppose with so many controversial and upsetting actions by the presidents, these acts of destruction and proposed destruction to our landmark has so captured the public's attention and so angered us?
Well, landmarks are something that we all experience. And they do come with such, with rich symbolic meaning. And so if people perceive that those meanings are being altered or impaired, they're going to respond. And as Judge Leon said in the White House ballroom case, the White House doesn't belong to the person sitting in the White House at that particular time. And so I think people have the feeling that the obligations of stewardship are not being respected.
Yeah.
I think they're really physical embodiments of what's happening in a way that people, I think, can see. They're, and people talk about the White House being the people's house, but all of these memorials and all of these monuments, they belong to all of us. they don't belong to any one person. They shouldn't be controlled, and they shouldn't be shaped by any one individual's whim. And I think that's what a lot of people are reacting to, that it's sort of a way of quantifying and focusing. Like I say, I talk a lot about the Kennedy Center, and I understand that it's not the most important thing happening out there in the world, but it also is a really important symbol of what is happening. And I think all of these cases represent symbolically something that's very tangible for people in terms of what is happening in our government as a whole.
Thank you. Really grateful for this panel. Edwin, I was trying to remember a quote from an article that you sent yesterday about, our democracy, our liberty is dependent on our processes, which I think we really learn from these cases. So if you have that, feel free to share it, but I believe that is it. But I just want to really thank our panelists. And what emerges across all of these disputes is that the legal framework is not absent, but its force depends on setting, institutional design, how the laws are mobilized, and really what courts are also willing to do in practice. But thank you for also explaining ways that we all can monitor and get involved in this. It's important. So on behalf of everyone here, thanks to our panelists and for everybody for participating. Thank you. And this concludes our webinar.